Make.
My brother wants to ask.
Yes.
He just wanted, in your formulation, if I may draw your attention to the reference question may have to be reformulated thus.
Yes, my lord.
Point 8.
Yes, my lord.
And there you have said, if you just come there,
Yes, my lord.
you may just read it once, and so that I'll just point out where I am.
Because I have unilaterally sought to delete some
No,
words.
so that's right. So just read it so that we'll all appreciate it together.
Now that the argument has been made, your lordships will be in a better position to appreciate.
No, there. So what you are saying is whether the statutory bar contained in section 35 of the Stamp Act applicable to instruments. Point 8. For page 5. Page 5.8.
No, so I've tried to reformulate the.
That's right. So just putting it across to you. Applicable to instruments chargeable to stamp duty under section 3, read with the schedule to the Act, would also render the arbitration agreement contained in such an instrument. Then you have struck out few words.
Yes, my lord.
As being non-existent. I'm just pausing here.
Yes.
As being non-existent, should we say, because of the words that you have incorporated thereafter, non-existent temporarily?
My lords, I have just used non-existent because the section uses the word existence.
No, correct.
Yes.
So non-existent
Temporary.
because pending payment of stamp duty on the substantive.
Right.
So it is non-existent. You are not saying for not forever.
My lord,
obviously for the limited time until the stamp duty.
I am
is
going
paid.
one step further, my lord. I am saying it is existent, but it is not enforceable. It exists today in present time. So, my lord, non-existent would be it would not exist, but it exists today in fact and in law. Today, there is in an unstamped agreement, my lord, the submission is that as on today, assuming an agreement is unstamped, it exists as a matter of law because it is, my lord, a valid agreement. It is only, my lord, a curable defect by which that defect can be removed and it can, my lord, be then implemented. So, my lord, I am going.
So, non-existent, then should you not qualify that with something?
With something, my lord, yes. Possibly temporary.
You may think about it. I'm just putting it across to you because
yes, my lord.
You are trying to reformulate.
I am trying to, my lord, reformulate it only. The reason I didn't want to tamper too much, my lord, with the.
So just think about it. Something may have to come here.
Something may have to come.
Very well.
Please. My lord, should now be reference judgment in Garware. I was showing your lordships the Garware judgment, which is the sheet anchor, my lord, of the basis of the reference. Justice Nariman's judgment. Have your lordships
yes.
got that judgment? My lord, the relevant paragraphs that are fall for consideration before this court are paragraphs essentially 18 to 22 and 28, 29. Those are the ones, my lord, which are also, my lord, have been referred specifically to the Constitution Bench, particularly 22 and 29. So, my lord, I have some comments on these paragraphs and some, my lord, criticisms which one makes with trepidation. After all, my lord, it is a judgment of this honorable court of 2 honorable judges. But I have in my favor, my lord, 3 honorable judges who have not agreed. So I can, my lord, legitimately make some criticism, even, my lord, though it is a judgment of this court. So, my lord, with that caveat, my lord, may I say some things about this judgment. Please, my lord, insofar as paragraph 18 is concerned, which is at page 22, which your lordships had seen on the last occasion, on internal page 230 of the judgment, the division bench observes that it will be noticed so and so. It is settled by SPP and Company that section 16 of the 96 Act has full play only after the arbitral tribunal is constituted without intervention of the court under 11. Lord, this qualification was added by the 7 judges. They go back to the concept of court with intervention of court, without intervention of court. That aspect, my lord, stands legislatively overruled, though that ghost of my lord still seems to haunt us. It is also referred to in Justice Khanna's judgment, because after all, my lord, 7 judges, it's difficult to reconcile the fact that the legislature has, my lord, changed the rules of the game, as it were, but it has, my lord. 232, my lord. Page 24. In view of the law laid down by the 7 judge bench, difficult to exceed the argument made by learned counsel on behalf of the respondent. Section 16 makes it clear an arbitration agreement, the independent existence of its own, must be applied while deciding an application under Section 11. Well, Lord, I would respectfully submit that this may not be quite correct. Certainly, when deciding what is the scope of 11.6a, your lordships will also take into account Section 16 and give it whatever the meaning